common question is, what happens if I pass away? Well, if you have no will, in effect, the property will pass pursuant to state law. And the state law that controls is the state in which you reside as your primary residence. And normally that's the one where you have your driver's license. So it's state law specific. And then it's called intestacy because you don't have a will or a trust that will actually dictate what happens upon your death. And so a formal administration is actually established for you by someone in close relationship to you that decides to open a state for you. So they have to petition to be the executor of your estate and to open an estate on your behalf in the county and where you live in the state that you live. And when you have an intestacy situation, basically all assets will pass pursuant to that state law. So you're not really in control of who gets your assets, who manages your business, who actually takes control of your any accounts that you have, who will be your guardian for your children in the event that both you and your spouse are deceased, or the children do not have an additional parent. So be very careful. This is the reason why we want to actually establish at least a basic will for you, and to get you on the road to creating a larger estate plan based on your current situation. Now, the intestacy statutes and whether or not you have a will or trust also will not control assets where you've left a beneficiary. So if you have life insurance and you left the beneficiary of that life insurance is your sister, then your sister will actually receive those assets. Likewise, if you own a home in joint tenancy with right of survivorship with another party, most of the time it's your spouse, it goes directly to them, so that does not come through your estate at all, and that won't be affected. Now, if you do have a will or a trust, and normally with a trust we have a pour-over will anyway, and sometimes in a will we have trust provisions. So the object and the goal of that is to actually give you the opportunity to have control of what happens in the event that you pass away. It is state specific. Again, all of the will and trust regulations, statutes, and so forth are pretty much similar throughout the country, but there are a lot of differences, and we'll explain those in this course. With a will, there is a formal administration, and with that, the formal administration will vary based on how much basically in assets that you have. So it might be just a mere administrative process for a very, very small estate, or it might be a longer and larger, more expensive process for someone who has substantial assets. The will definitely go through a probate process, and in some cases it's beneficial to do that. The probate process, basically the executor admits your will to probate. They collect your assets, they find out where your accounts are, they actually turn around and obtain information on who your beneficiaries are, who your creditors are, because your credit cards, your medical expenses, all of these things need to be paid, and they're paid out of your estate assets. If you do not have a will, or you just have a poor will with a trust, the trust assets are going to be liquidated, and you do have a process in every state for notifying the authorities that you have a trust in place. So with a trust, normally we file what's called a notice of trust, And that puts others on notice that, if they do have any creditors' claims, that they can actually contact the trustee, and that the trustee will pay them on your behalf. Normally the trustee is also the executor of your estate. Sometimes it's different, but most of the time you actually have, and you want to appoint the same party. Again, if there's an asset with a beneficiary designation, sometimes we have bank accounts where we put a beneficiary on that. It's called a transfer on death account. Then the bank account goes straight to the individual, and it does not come through your estate. Any real estate that you own that has right of survivorship, it will go to the survivor. If you have a spouse that's alive, any joint accounts normally go straight to the spouse, as long as they are a current spouse and you're not divorced from them and there's no divorce decree. So, that's a little bit about what happens when you pass away. If you have children, you can name a guardian in your will, and you can put trust provisions in your will or in your trust to make sure that your children are provided for in a certain manner. Distributions are made when they're a certain age. The guardian, naming the guardian is very important, because the courts will actually look at that as being priority, as long as that party actually qualifies as a guardian, and they're when they file a petition to be the formal guardian, that it is not contested. So do keep that in mind, that there is an additional process past the naming a guardian in your will, but your will does carry weight on who will be accepted as your guardian. So, if you have any questions, please do mention them in the group. But for all intents and purposes, take action after, this section and lesson of the course, and do the required tasks, and we'll see you in the next lesson.